Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager here at Bond. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and our presenters will do their best to address those as time allows. Once the webinar has ended, we would appreciate you taking a moment to complete the survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Andy Bobrock.
Kathy, thank you. Good to be with you. Good to be with everyone on the webinar. Just to echo Kathy's point on the surveys, we do actually read those every time we get done, and we really value your input. And I know everyone's incredibly busy, but if you have 90 seconds you can spare at the end of this, please do. We really welcome your feedback. Want to know how we're doing. We're doing this for you, and we want it to be of value to you, and your feedback can help make sure that that takes place. We have a fantastic panel today. So going to get you some great information on a wide range of matters. Before we do that, I just wanted to touch base real quick on some issues here and give you a sense of, hey, what's going on right now on my desk? Not that my desk is, all that interesting compared to any of my colleagues' desks in the labor and employment world, but I thought I'd go through this just to see, these are the issues that I'm seeing with prevalence that are coming across my desk and that I think perhaps you're seeing on your end too, and I just wanted to mention them. So first and foremost is, what's going to happen with OSHA's mandate, its vaccination mandate, its ETS, for employers with 100 or more employees. Peter Wiltenberg is with us today. Peter's going to cover this issue for you in just a minute when I turn it over to him. But that's a big issue. That's a lot of questions that I'm getting right now. I am getting a lot of questions and working with clients on New York HERO Act compliance issues. We have, I think, for the most part, successfully pivoted from the Infectious Airborne Disease Prevention Control Plan. That's a mouthful. And now we're starting to look at the November 1st effective date for employers to be ready, covered employers to be ready to potentially implement and create a workplace safety committee if an employee raises their hand and says, yes, we'd like to create this at work. I'm seeing, at least here in the central New York area where I'm based, although my practice really covers the entirety of the state, I'm hearing more reports from employers about positive employee tests, that they're seeing greater incidence of these tests among their workforce. And then this is raising the question of, well, what do we do? What do we do now? Again, a lot of the what do we do has been pushed down to the local level. We do have guidance from the federal government through the CDC in terms of steps that can be taken. But I think if you're not experiencing this already, it would be a good time for you to take a look and figure out, how would we answer that question? What are we going to do if an employee tests positive? By and large, that'll be driven likely from local government and local departments of health that will issue quarantine orders. But as you know, that can quickly cascade into a number of related questions and issues, including the availability potentially of paid leave for the employee and any other obligations on the employer's part to safeguard and protect other workers from infection. Again, if you're not facing that, the concern I have is that you could be, and you're going to want to have the answers ready and a process ready in terms of how you're going to address a positive employee test. Interestingly, the other thing that I'm seeing on my desk right now are cases that I would say have languished for an extended period of time, months, maybe even years, with the State Department of Labor. And those cases starting to resurface now, including with adverse findings against clients, where an investigation or inquiry or information request was complied with a long time ago, maybe even pre-COVID. And this raises a number of issues, and I think is the result of, in some instances, the Department of Labor investigators moving away from initially handling the deluge of unemployment issues, including fraud claims that had to be handled, and then COVID issues, and now kind of returning to the so-called bread and butter or their usual activities there. So if you have pending cases, keep in mind that you could be seeing some notices on that. Interestingly, I am seeing more cases of employment discrimination and harassment claims come across my desk, whether through court or with administrative agencies like the SDHR, the EEOC. I can't really explain that. There does seem to be, waves and somewhat of a cyclical element to that. But that nonetheless, I am seeing those incidents. And again, for me, what the takeaway for you is, hopefully you're not experiencing that. If you are, obviously, you want to work with legal counsel, and we're here to help if need be. But two, again, it really places a premium on employers to make sure that, A, you have robust policies prohibiting discrimination and harassment, that you have proper procedures in place, and again, keeping in mind what's required in New York State when it comes to sexual harassment in terms of policies and training. And again, the premium is what you do as an employer when those issues are brought to your attention. How do you react? How do you handle it? That's what really matters when you get right down to it. And being ready to address those issues is crucial right now. And finally, recruitment and retention. We continue to have, as I've reported before, an incredibly tight labor market right now, placing tremendous pressures on wages and other issues, and making it very challenging to recruit and retain workers right now. No magic bullet to address that issue, but again, there are strategies that can be implemented. And a plug for our breakfast briefing. We'll get more information out to attendees on that, but we're going to have a breakfast briefing that will solely address this issue and is designed to help give you some additional arrows in your quiver to address these issues and address any recruiting or retention issues. All right, so that's what's on my desk right now. I'll try to report back on these issues if people find this interesting. If not, we'll ditch it and find something else of note. So I'd like to, at this point, turn it over to my colleague, Peter Wiltenberg. Peter is an associate in our Buffalo office, great attorney, has presented before, and we're glad to have him here today. And Peter wanted to provide an update to everybody on where things stand right now with respect to this vaccination mandate that is pending and potentially coming forth from Osha, and what to expect potentially in the future. So Peter, great to have you with us today. Thanks.
Thanks, Andy, and good afternoon, everyone. So as Andy mentioned, just last week, we saw some progress on the president's plan to impose a vaccine mandate on many employers in the private sector. So just to kind of get you up to speed on that, I'll do a little bit of a recap about how this transpired. On September 9th, the president directed OSHA to create what's called an emergency temporary standard. And this is basically an emergency rule that skips the normal lengthy review process and can be enacted much faster. And the rule that the president wants from OSHA is to require employers with more than 100 employees to either mandate their employees get vaccinated or require a weekly test. And just keep in mind that on that same day, on that September 9th conference, the president also announced a different vaccine mandate that applies to most federal contractors. That's a separate rule that we've discussed at different times. So since then, everybody's been waiting to see what OSHA is going to do with this direction from the president. And then finally, last week on October 12th, OSHA sent its ETS to the White House's Office of Information and Regulatory Affairs, usually called OIRA, for review and approval. So as I said, the normal review and approval process often takes months. It allows for public comment and review. This process is going to be completely different. This is an emergency standard, and it's likely going to be approved any day now. A lot of people even thought the White House was going to approve it before the end of last week. Last time I checked, about 45 minutes ago, they still haven't done so, but it's likely coming pretty soon. Please go ahead to the next slide. So since OSHA is the one who's issuing this rule, I thought I'd just give a quick few backgrounds on OSHA. In 1970, Congress passed a law called the Occupational Safety and Health Act, which created the Occupational Safety and Health Administration, which is what OSHA is. It's part of the U.S. Department of Labor. Its mission is to ensure safe and healthful working conditions for employees. And OSHA's jurisdiction can be a little bit confusing because some states have an arrangement where they're directly subject to OSHA's rules and standards. Other states have their own agencies that have a very similar mission and create rules and standards that are at least as effective as OSHA's. To make it a little bit more confusing, New York is one of the few states where OSHA's rules and standards apply to employers in the private sector, but public sector employers in state and local government are subject to a New York State agency called the Public Employee Safety and Health Bureau, which is usually called PESH. But for all intents and purposes, when OSHA does something, PESH is going to create a standard that's at least as effective as the OSHA standard. So that's generally what we'll be paying attention to. Next slide, please. So what's going to be in this OSHA rule? Of course, we don't know yet for sure because it hasn't been publicly released. All we know is that OSHA sent it to the White House last week. We do know what the main parts of it are going to be from what the president has said that he wants. So, of course, the main thing about it, as we've already said, is that it's going to require employers in the private sector with more than 100 employees to either require that their employees get vaccinated or get weekly negative COVID tests. It's probably also going to require employers to pay for the employees to go get vaccinated for the time that they spend doing that, and for any time that they have to take off due to recovering from side effects that they might have from getting the vaccine. As most of you know, that last part is already the law in New York, but the OSHA rule would likely try to make that apply nationwide. Now, since we haven't seen the rule yet, there's still lots of unknowns about the details and how it would be implemented and various other considerations about it. So there's an infinite number of unknowns, but some of the ones that seem to be mentioned the most are things like how do we count the number of employees? Is it going to be by location? Is it going to be by is it going to be a similar test under other federal laws? Are employers going to be required to collect proof of vaccination from their employees? What types of tests would be required or sufficient to satisfy the rule? And will remote employees be covered? These are all things that we hope would be clarified by the rule when we actually get to see the text of it, but we never know how clear that's actually going to be. Next slide, please. So one of the biggest unknowns about this rule, or the ETS, is whether it's ultimately going to survive legal challenge and ever really become effective in the first place. So as we know, likely lawsuits are being drafted as we speak that are going to be filed almost as soon as this rule becomes effective, trying to challenge the rule and block it from ever really taking effect. So again, because we haven't actually seen the rule yet, we don't know exactly what form those legal challenges are going to take. There are probably going to be many. But from what we think is likely in the rule, we have a good idea about some of the most likely challenges that we're going to see. So the first one, it has to do with the process of creating an emergency rule. The law basically says that OSHA can only issue emergency rules when necessary to protect employees from grave danger. OSHA might have a hard time, or the government might have a hard time defending the rule as being necessary to prevent grave danger when they've waited about 9 months to try to implement this rule in the first place after vaccines have become widely available. Another thing they're going to have a hard time probably defending is the notion that it only applies to larger employers. Why wouldn't employees of smaller employers with fewer than 100 employees be subject to the same grave danger that employees of large companies or employers are? So that's something that OSHA is going to have to defend likely in court. The second thing is whether OSHA even has the power to mandate vaccines in the first place. There's an open question as to whether Congress has the power to do something like this as one of its enumerated powers in the Constitution. If Congress doesn't have the power to mandate vaccines, then it can't delegate that power to OSHA. So this power might not really exist at all. And secondly, another basis for challenge is that even if Congress does have this power in the abstract, it can be argued that it never actually delegated that authority to OSHA. The language of the Occupational Safety and Health Act would have to be interpreted to see if it actually encompasses this kind of rule. And finally, this is a little bit just on the implementation itself. To the extent that the rule actually requires employers to pay employees for the time that they spend going to get vaccinated, OSHA might not have the authority to do that. Generally, there's another federal law called the Fair Labor Standards Act, which governs pay, and OSHA may not have the authority to set rules about pay for what employers have to do. So again, these are all, we're just speculating right now as to what kind of challenges there are going to be and how likely they are to succeed. It's going to depend on what the rule actually says, but a lot of commentators believe that these legal challenges have a pretty strong basis and that there's a pretty strong likelihood that this rule, at least in part, could be blocked once it's actually challenged in court. So of course, we're going to keep a really close eye on that as soon as the rule becomes effective and anybody tries to challenge it. Next slide, please. So finally, the last thing is, even though the rule could be blocked in the courts, there's still some things employers can do to prepare in the meantime to try to get ready for this rule becoming effective if it does, or another similar rule, which could ultimately come from the state level as well. So employers can right now set up a procedure for trying to determine the vaccination status of your employees. Many of them probably already are vaccinated. Secondly, try to set up a procedure for tracking those weekly test results. If your employees are going to be generating test results and submitting them every week, there's going to have to be a good system for keeping track of those. And finally, prepare for the possibility of employees refusing to comply and prepare an appropriate response, which in some cases could include termination. So that's all I have on that rule. The ETS, we'll keep a close eye on that.
Peter, thanks a lot. That's a very helpful overview. And I think it's an issue that everyone's keen on. And there's just this significant gap right now in terms of what we can actually piece together without seeing the ETS coming out. Am I correct that in this this list of questions that we all have, the timing of any implementation is also uncertain at this time? Is that fair to say? Usually with a regulation, there'll be a 90-day period, maybe longer, before it goes into effect. Here, we're not really hearing one way or the other on this. Is that right?
Absolutely. That's certainly one of the top open questions that's on everybody's mind. I think most people expect that it's going to be a much faster implementation period than you would normally see. The exact amount of time, of course, we don't know, but I think employers should probably be prepared for, if it gets put into effect, that compliance time would be pretty quick.
Great. And Peter, I won't put you on the spot with this issue, but welcome, your feedback. I know one question that we've gotten in the comments and that we've regularly fielded from clients and friends of the firm deals with the compensability of time where this testing is taking place, or for the testing itself. And the answers to those questions, as I see it, are going to be dependent on your individual facts and circumstances. And it's certainly something that you're going to want to discuss with legal counsel, because there isn't necessarily a one-size-fits-all answer to those questions. Peter, I don't know, on that point, if you have anything to add. The only other thing I would mention too is, when it comes to testing, one thing I think that we're going to keep our eye on if the ETS does come out is, to what extent can at-home tests be used for this testing process. I can report that the FDA has approved a number of testing kits, at-home testing kits, I believe under EUA authority. There's a list of that on their website. So that's something I think for you to consider too, as employers moving forward, how to fold that in potentially. Peter, sorry, anything to add on that at all?
Yeah, no, I would, nothing much to add other than those are all great questions to keep an eye on. On the paying employees for the time to get vaccinated, it'd be interesting to see if it's a requirement beyond what we've already seen from New York State in terms of the amount of time that employees get compensated for. And with the testing too, it's, as you said, there are a lot of available tests on the market, and it's also been a difficult question as to whether employers have to cover the cost of those. if you're doing it every week, that can get expensive pretty fast. So
Yep.
no good answers on those yet, but certainly something we'll keep an eye on.
Great. Peter, thanks again. Appreciate you joining us. Hope you'll come back soon.
Thanks.
All righty. Next up is Hannah Redmond. Hannah works in our Syracuse office here, just down the hall from me, not a long ways. We work together on a whole host of labor and employment issues. One issue that Hannah's been tracking closely is the decriminalization of cannabis use in New York and modifications to a particular statute, once upon a time an innocuous statute, but now relevant, the 201D of the New York labor law, and some guidance that state officials recently published for employers on this subject. So Hannah, great to have you with us. Thanks for being here. And what's going on here?
Thanks, Andy, and hello, everybody. Like Andy said, today we thought we would provide an update on recreational marijuana, given some recent guidance from the New York State Department of Labor, which came in the form of frequently asked questions and which addresses the legalization of recreational marijuana and its impact on the workplace. As many of you are probably aware, and as we have presented on in the past, Labor Law Section 201D was amended earlier this year by the Marijuana Regulation and Taxation Act to include the use of recreational marijuana, which, as Andy kind of indicated, is no longer an illegal substance under New York law. Before we jump into the DOL's FAQs, I want to make sure that we're all on the same page. So I'm going to very briefly give an update or a background on Section 201D. So under Section 201D of the labor law, marijuana is now a consumable legal product. And that means that employers generally cannot discipline employees or take other adverse action against employees because of their use of recreational marijuana outside of working hours and off an employer's premises. Now, there are a few limited exceptions to that prohibition. I'm not going to do a deep dive on the exceptions, but they essentially provide that employers can take adverse employment action against an employee if the employer's actions are required by state or federal law, if the employee is impaired, meaning that he or she manifests specific articulable symptoms of impairment. And we're going to talk a little bit more about what that means and does not mean in a minute. And the third exception is the employer's actions would require it to violate federal law or experience a loss of a federal contract or federal funding. And that last exception is getting at the fact that marijuana remains illegal at the federal level. Okay, so bearing that background in mind, let's talk a little bit about the DOL's frequently asked questions. The FAQs largely confirm what we knew following the amendments to Section 201D in March of 2021. So for a lot of you who have been keeping track of this issue, this might just be a refresher, but they're all good things to keep in mind. The first portion of the FAQs talked about employee discipline. A substantial portion of the FAQs were focused on this subject. We know that 201D generally prohibits employers from disciplining employees for their off-duty, off-premises use of recreational marijuana unless one of those exceptions I just ran through applies. Impairment is one of the most significant exceptions, and the FAQs reiterate that the impairment exception allows employers to discipline employees who are impaired such that they, and I quote, manifest specific articulable symptoms of impairment that diminish their performance or interfere with the employer's obligation to provide a safe and hazard-free workplace. Because Section 201D did not define the meaning of specific articulable symptoms, the meaning of that standard and how to apply it has been one of employers' largest questions following the legalization of recreational marijuana. Unfortunately, the Department of Labor did not define specific articulable symptoms in the FAQs. Instead, they stated that there's no dispositive and complete list of symptoms of impairment. And the FAQs also went on to say that articulable symptoms of impairment are objectively observable indications that the employee's performance of the duties of their positions are decreased or lessened. So it's kind of a mouthful and it's a bit vague, but The DOL did give some guidance in terms of what is not a specific symptom of impairment. The first being observable signs of marijuana use without more. So this tends to suggest that physical signs stereotypically associated with marijuana use or consumption by themselves cannot be cited by employers as a symptom of impairment. To me, this means things like red eyes, or the FAQs specifically refer to the noticeable odor of marijuana. So that is the smell of marijuana by itself is not a symptom, an articulable symptom of impairment. The FAQs also tell us that a positive test for marijuana cannot be used by itself as a basis for an articulable symptom of impairment. And that is because there's no test currently capable of indicating when an employee consumed marijuana or letting an employer know if the employee is intoxicated at the time of the test. The next subject the FAQs discussed was the use and possession of recreational marijuana in the workplace. The FAQs reiterate that employers, can prohibit the use of recreational marijuana during meal periods and rest periods, including meal breaks and rest periods when employees are allowed to leave the physical workplace. So employees who leave for lunch or run home to do an errand, they may be prohibited from using recreational marijuana at any point during their workday. And that's true whether or not the meal period or rest period is paid. The FAQs also state that employers can prohibit employees from using recreational marijuana while they're on call or while they're expected to be engaging in work. Similarly, employers can prohibit possession of marijuana at work, and this includes the employer's premises, whether or not it is leased, rented, or owned, employer-owned vehicles, and in other spaces that are typically thought of as belonging to an employee, so like a desk or a locker. Employees can be prohibited from storing marijuana in those spaces. Drug testing was the next substantial topic addressed. And this is where we got some surprises from the Department of Labor. Employers' ability to test for marijuana was similar to the meaning of specific articulable symptoms, a big question following the legalization of recreational marijuana. Employers wanted to understand their ability to test and how the legalization of recreational marijuana impacted their pre-existing drug testing policies. It's very important to note that the statutory text of Section 201D does not address drug testing one way or the other. It's totally silent with respect to drug testing. However, in these FAQs, the Department of Labor has taken the position that drug testing is not allowed unless one of the exceptions we discussed at the beginning of the presentation is met. So it appears to be the Department of Labor's position that most employers should not be conducting pre-employment drug testing for marijuana or random marijuana testing unless they meet one of those exceptions. It's important to remember that impairment is an exception. The FAQs are not totally clear with respect to reasonable suspicion testing, but it seems to be that employers may still conduct reasonable suspicion testing when there are specific articulable symptoms of impairment that indicate the use of a drug test might be appropriate. Finally, there are a few miscellaneous points addressed in the FAQs that I think bear mentioning. The first is employee waiver. The FAQs let us know that employers cannot require employees to waive the protections of Section 201D as a condition of future or continued employment. The FAQs also address employer and employee coverage. All New York employers are covered, and this includes public and private employers, and most employees in New York are also covered. The one major caveat to that is that employees under the age of 21 are not covered because they cannot legally use recreational marijuana. Students and student employees are also covered. The FAQs do specifically point that out, and again, just subject to the requirement that students only students over the age of 21 are protected. And there are also geographical limitations on the coverage of Section 201D. Only employees working in New York State are covered. So that means employees working out of state, including remote employees who are working for a New York State employer, are not protected under 201D. And then finally, the FAQs clarified that the amendments to Section 201D only apply prospectively. So that means employees who were terminated or disciplined prior to the legalization of recreational marijuana do not have any right to reinstatement now that it's legal. So I know that was a lot to digest. That's all I have for you today. But before I turn it back to Andy, if anyone has any questions, please feel free to get in touch with me or anyone at Bond, and we'd be happy to help.
Hannah, thanks a lot. That was very helpful. And for those of you attending who may not already be subscribed, Hannah drafted a very helpful, detailed explanation about these FAQs on our blog, the New York Labor and Employment Law Report. You see Hannah's email there. I'm sure she'd be welcome to send you a link to that if you want to reach out to her by email. But again, that'll contain a lot of the same information that she covered here today. Hannah, one question that jumped out at me, this guidance on the, thou shalt not drug test. Seems not entirely clear. I guess still leaves some room for maneuvering. I think you mentioned that wasn't something that was in the statute. Is that correct?
That's correct. Yep, that was the one big surprise about these FAQs. The DOL's position is frankly not supported, or it's just not addressed by the statute itself. So we'll have to wait and see where that issue takes us.
Right. So I think our advice for those attending here is, first and foremost, with respect to this issue and how you're going to incorporate THC testing into your policy and procedures, it's something you're going to want to discuss with legal counsel and take into consideration this guidance here. To this point, candidly, I think we looked at this as, the testing pre-employment really didn't make any sense at this point any longer, since it's indicative of nothing, right? In terms of potential workplace concerns, but there still could be some value as a data point, not a dispositive data point, but as one data point, if there is an employee who has these articulable symptoms that you're looking at, and that the testing could go hand in glove with that. Again, not as a dispositive issue, but as a data point there. That's something you're going to want to have to get comfortable with as an employer and figuring out how you're going to go about this issue. And again, we're in this usual position of there being some gaps in statutes, some guidance that doesn't make entire sense necessarily, and you, our clients and friends of the firms, having to sort all this out. So thank goodness we have people like Hannah who are tracking this and providing this kind of guidance. So Hannah, thank you very much.
Thank you.
All right. Last up, we have Katie Anderson. Katie, so I thought, we keep doing these Albany updates. Let's do Helena, Montana today instead. All right. I mean, I didn't give you a warning on this, but let's switch it up. What's going on in Helena?
Yeah, it's if you want me to cover Helena, Montana, Bond has
next week. All right, I'll give you a week. I'll give you a week.
Yeah, that's right. So give me a flight. I'll go out there and report. But you ignored what's happening in a more interesting state out west, looking at Idaho and what happened when their governor left the state and the lieutenant governor took over. If you don't know what's happening there, you should absolutely look that up, because it is one of the more fascinating stories about executive power that exists in modern history.
Not the first time either, right? This was the second time, right?
It's not.
Yeah.
But unfortunately, if I give the update on what's happening in Montana, I don't have a view of the Montana Capitol like I do from my current office.
All right.
So we must stick with Albany, unfortunately. All right, so let's get this rolling and start where we always do. Looking at cases, again, we have this plateau that we've been in since August. cases in the past week, we have seen take a pretty consistent nosedive. The places in New York State where cases are the highest are generally out in either Western New York, the Southern Tier, and Central New York. There's a few in the North Country, but downstate is looking great. The capital region is high, and it is increasing, but it's not at the same level as it is out elsewhere in New York. So looking at the numbers, we have seen case numbers decrease over the past week, the past 14 days. The rate of change has been -8%. Again, this is good news, but pure speculation here, right? We have to be thinking ahead about what's going to happen with the HERO Act. Based on these numbers alone and nothing else, I do think that the HERO Act will end up being extended into November. And again, that's just pure speculation on my part. It's a question I get asked a lot, so I'm speculating for all of you. But hospitalizations, happy to see that number also trending downward. And here's this map. I wanted to include it just to show where cases are really happening in New York State. Every place in New York State, with the exception of Westchester County, is at a very high level of spread according to the CDC, or even higher. In some places are extreme level of spread, and so it's still pretty high in and around New York State, and that's consistent with the Northeast. It's really plateaued in the Northeast because of cooler weather driving people inside. So looking at vaccination progress, happy to show some numbers trending upward. All New Yorkers, we have a jump of 2% from last week. 66% are now fully vaccinated. 73% have received one dose. And looking at people 12 and older, 76% are fully vaccinated and 85% have received one dose. And here I'm going to pause and really just quickly discuss something that the governor was talking about today. Shots for kids. It's expected now, according to Governor Hochul, that the FDA will be approving the Pfizer vaccine for kids 5 to 11 in November now. So that's a change in timeline from what we had originally thought. The governor said, early November is when it looks like this is going to happen. And her recommendation today, she gave a press conference. Her recommendation is that if you have a kid and you're trying to get your kid vaccinated, make an appointment now for sometime in November, because those slots will likely be filling up quickly. So that's that vaccine news, but don't worry, I have plenty of other vaccine news for you. There's been a lot of updates with booster shots. So last week, the FDA advisory panel backed the use of Moderna and Johnson & Johnson booster shot. That full approval is expected at some point this week. It's unclear when it's going to occur. I'm always of the mind that these things will always happen while we're giving this presentation. So let's see if it happens today at some point. There is a chance that the FDA may authorize mixing and matching booster shots. So what does that mean? If you've received the Johnson & Johnson shot, for example, then perhaps the FDA will be authorizing that as a booster, you receive Moderna. Or you have Moderna and the FDA may allow you to receive a Johnson & Johnson booster. This remains to be seen. The preference clearly is still to use the same vaccine that you had, but if there's only one type of vaccine available in your area, then they don't want to be discouraging people from receiving a booster shot. What is also expected this week is that the categories of people eligible to receive a booster will be expanded. I am not sure what that will entail, but because there has been confusion about who is eligible to receive a booster, I figured it's worthwhile to go over the current rules about who can receive a booster shot. So this is directly from the CDC website. The CDC does recommend that the following groups should receive a booster shot, right? So these are the people that should receive it. People 65 and older, people who are 18 years and older in a long-term care setting, and people 50 to 64 years old with certain underlying medical condition. And these booster shots should be received at least 6 months after completing your first Pfizer round. Remember, we're still talking about just Pfizer here. And then there is the secondary recommendation, which is a booster shot should be made available so that the following groups may receive a booster shot of Pfizer. Those following groups are 18 to 49-year-olds with underlying medical conditions and people aged 18 to 64 years at an increased risk for COVID-19 exposure and transmission because of an occupational or institutional setting. Lots of places have been saying, so what does occupational setting mean? This is another page from the CDC website. If we could get the next slide, Kathy. Thank you. And this is, again, directly from that website. That's the link at the bottom to this website. These slides will be published and we'll be able to access them, I believe, by tomorrow. So looking at this, you first have to examine, what are factors that affect or may affect employees' risk for exposure for COVID-19. And looking at, those 4 factors at the top: unavoidable frequent interactions with possibly unvaccinated people, adherence to other prevention measures, those things are there, but that's really unclear guidance. So let me just give you a more clear-cut example that is from the CDC about who may receive the booster shot. The first up is looking at first responders, educational staff, food and agriculture workers, manufacturing workers, correction workers, U.S. Postal Service workers, public transit workers, and grocery store workers. If you have questions about whether or not your specific industry or your specific workplace could potentially qualify people to receive a booster shot, get in touch with an attorney to go over this, just because this can be complicated to go over whether or not they can go receive the shot. But if you want to wait, you may want to wait a second, because again, it does appear that the FDA is going to be broadening the categories of who can receive the booster shot. All right. So that's what's up with booster shot news. And now I finally get to be the one to report to you about U.S. borders. So we are seeing opening of the U.S. borders to some people and closing of the U.S. borders to a significant population of the globe. The U.S. is going to lift restrictions for vaccinated foreign travelers on November 8th. What does that mean? That means that if a person is fully vaccinated and traveling to the U.S., that's fine. They can come. But when you look at where vaccination rates are, it does effectively cut off travel to the U.S. by quite a few places, namely the entire continent of Africa. Only 4% of the people there are vaccinated. So there goes that opportunity. So let's look at what's more specific, though, to all of us, and what is something that's been of concern. Obviously, the Canadian border. What do people have to do if they are traveling back and forth between the U.S. and Canada? The U.S. rule is that you're traveling by overland, so you're traveling by car, then there is no need to show a negative COVID test, just proof of full vaccination. If you're traveling by air, however, there will need to be proof of a negative COVID-19 test. Now, all of these rules have been said in press conferences by the CDC, by the White House, so none of this is in a good document that I can just push out to all of you. This is all just disseminated information from those reports. At some point, official guidance, I'm sure, will be updated to show this, but until then, bear with me. There is no quarantine requirement for fully vaccinated travelers coming into the US. And the big question, the question that many people have asked is, what are considered acceptable vaccines? And the good news is that the US decided it's not just FDA approved vaccines, it's also vaccines that have been listed for emergency use by the World Health Organization, the WHO. Why is that important? Because many people have received the AstraZeneca vaccine. And that is not FDA approved. They never came to the FDA for that approval. They didn't go through that process. But the good news is that those people will be able to come to the US. The other two vaccines on there that are not authorized by the FDA, but are authorized by the WHO are Sinopharm and Sinovac. Both of those have primarily been used in China. They were both developed in China. But what's important here is that Sputnik 5, which is the primary vaccine in Russia, has not been approved or listed for emergency use by the World Health Organization. So this precludes travel from Russia, broadly speaking. Russians will likely not be able to enter the US. And many Slavic countries where the Sputnik 5 vaccine has been distributed will not be able to come to the US because of that, or if and until it is listed for emergency use by the WHO. You can see that this change in policy may push people to list this vaccine as, for emergency use authorization. For US citizens, if you can get into a country, that's a big if, but if an unvaccinated US citizen can get into a foreign country, they're not going to be precluded from returning to the US. They will need to show negative tests upon arrival and then a few days after returning to the US. I believe that is my last slide. So with that, I will kick it back to Andy.
Katie, thank you very much. Lots of interesting information in there. All this will continue to develop, and we appreciate you keeping tabs on this. All right, everyone. Thanks to our panel. You see everybody's contact information there. Please feel free to reach out to them if you have any questions in these or other areas, or to your favorite bond attorney. We look forward to seeing you next week. In the meantime, be safe and be well. Thanks.